Good morning, ladies and gentlemen. My name is Aldo Engels, and I'm from a company called Labournet. To give a little bit of background of the position that I take is I've been with the company for roughly about 13 years, a specialist in industrial relations and litigation parts of it. And the talk that I'm going to give to you this morning is roughly that I'm going to talk a little bit about contracting, the wage bills, the employee life cycle, and what can be expected of you as an employer, and what are the rights and the duties of the employer versus that of the employee. And I'm going to break that down in some details with regard to how the fixed term contracting actually works, what type of fixed term contracts there are, permanent contracts, and how you can actually benefit from using them specifically in your business, and what's the best way for you to use them as and when required. Okay, so first things first this morning, as you can see on the screen, I want to start off with the employee life cycle. Now, a lot of people think that industrial relations or human resources plays a small part in business. In actual fact, if you look at the employee life cycle, it starts off with the recruitment and selection of the individual employee that you would like to appoint as such. After you've made this brave decision where you can actually look and go forward and appoint a person with the necessary skill, there needs to be an onboarding part. Now, the onboarding part is where you make your employees familiar with the company policies, procedures, the know-how, the internal systems that they need to work to, and what you expect from them through a cycle of behavior, how you deal with clients, how you deal with internal fellow colleagues, all those type of things. And this is quite important. And what needs to happen after that, after the onboarding is done, obviously, even in the recruitment phase, you would have a way that you would agreed upon what you pay and remunerate employees. Now, after this has been done, the remuneration part of these things, it goes on to employee wellness, to relearn employees through learning and development. There might be performance management or performance discipline through employee relations. We need to abide by our legal systems through BEE. And then the last part of the life cycle would be an employee exit, either through retirement agreement, retrenchment, or dismissal for some form of misconduct or incapacity. Now, with this being said, I'm going to focus predominantly on the industrial relations part of things this morning, with a focus as of where we need to look at in the life cycle as such with the industrial relations portion of it. Now, if you look at where we are, we normally start here and we start off with the employee relations part. And this is when you've already been employed. And I'm going to talk about how we get there and then what is expected with the rules and duties of employers versus employees. Now, first things we need to establish is there's a couple of know-hows to look at when we start off with contracting. Now, if you contemplate these things and appointing a specific employee, it starts off with what type of contract you would like to issue the individual. So we've got two types. We've got permanent and we've got fixed term. A permanent contract is an indefinite contract where you would tell the employee you work on a permanent basis, and until such time that you either retire, resign, or in the unfortunate incident of retrenchment, or if you commit misconduct, then the contract stays in place. Now, this is very nice if you have a stable company and you have the capacity or the need for a full-time employee or employees. This type of contract would work very nicely. However, if we look at fixed-term contracting, that I'll also unpack for us a little bit further, that changes and that's dealt with in quite a lot of different aspects that we would do. And there we will look at fixed-term contracting through an indefinite period. When I say this, this would be a project-based contract that's based on a project, and that's the defined period. And there would also be the one fixed-term contract with a specific end date. And these are the two main ones according to Section 108B, B, C, and D, according to the Labour Relations Act. I'll also touch on the duties of the employers, rules and regulations, substantive fairness, and then we might just touch on the outcomes as well. Now, what is a contract? The employment contract forms the individual employer-employee relationship that exists between a specific employer and a specific employee. Now, please bear in mind that this contract is between one party versus another party. Sometimes, if you ever heard of things called labor broking, there might be a tripartite agreement, but the law has outlawed that, not specifically outlawed, maybe it's not the right word, but made it quite strenuous that there's a joint and several liability between the person that you work for and where you are placed. So in actual fact, it just means that the relationship is between where you work and the person that gives you instruction. Now, from a legal perspective, a contract must be signed by both parties. Okay, once it's signed, it's a legal document, and this also confirms as an appointment letter which sets out the minimum information of the employment conditions. Now, in broad terms, the definition of a contract is an agreement entered into by two parties to create a legal obligation. Now, what this legal obligation is, it's a framework. So it's a function of a contract, and it's a framework, a legal framework, and this is what persons transact business on and exchange for whatever resources you would render. Now, to put this in quite some detail, what we would look at to say that you render a service, produce a commodity for somebody in return, not only for remuneration, but also for marketable skills that we normally call experience. Now, if we look at experience that the employee gets from this, the law says that the employer can choose how and where and what functions they need, as long as it's valid and reasonable. And I'll still unpack that a little bit later to say how do we deal with this as long as it's not illegal. And this is a common misperception where some employers go and say, or employees go and say that you can't do this, you can't do this. And that's actually quite a myth. So as long as a person can do it and it's not illegal, then the employer can actually expect certain things from employees and certain type of behaviors because it's your business and you choose how to run this business. So it's very important to remember these type of things. Now, if we start with this, and I said I'll unpack the employment relationship a little bit later, but if we go back to the employment contracts, for any agreement to serve the purpose of a valid and binding contract, the contract should uphold the following requirements. First of all, there must be a consensus between the contracting parties. The parties' intent in their minds must match, or at least must appear to match, on all material aspects of the agreement. So this is from case law that stipulates this is what an actual contract, the definition of it is. So you can't all of a sudden say, I've added a clause without anybody knowing this knowledge that my salary would be R1 million a month, and by accident the employer signs it and now this is due. The intention of a contract is not to be sneaky, but to agree upfront on certain conditions that both parties agree to in their minds and is comfortable with. The parties must also have the necessary legal capacity to contract. That means that you must understand it. It must be in a language of your choice, or it must be explained to you in a language that you understand, and that you must have the ability to understand what the person has been said. It might not be that you're an illiterate person and therefore you ask somebody to sign a contract. That would be null and void. Okay, so let me unpack this a little bit further, the contracting side, as I said. So the permanent contract is quite straightforward. You have a contract and you are the indefinite until a natural end. When it comes to it, all this misconduct that takes place. Now, as I said, a quite strong focus in South African law currently is the fixed term contracting. And what I mean with this is to say that fixed term contracting, there's certain definitions that must fall into place. Otherwise, it might be seen that you are deemed permanent. Now, let's unpack the fixed term part. I said, first of all, there's a fixed term contract that can be used with a defined period. Now, if there's a defined period, the law makes certain provisions. The first provision is you must establish whether the employee earns above or below the threshold as described by the basic conditions of employment. Now, the threshold is 205,433 Rand per annum, and this roughly equates to about 16,500 Rand per month. So if the employer earns above this, the law is a little bit more generous on the employer, and they say these employees can fend for themselves. So the law that governs them is Section 186, subsection 2. And what this basically stipulates is that if an employee claims that they've been unfairly terminated, they must prove that there was an expectation created by the employer to renew this contract on the same or similar terms. Now, it's quite a strenuous test that needs to be applied to the CCMA and labour courts. But if you want to have a look at these things, this is the rolling of contracts normally where it comes out, where an employee would come out and claim, my contract have been renewed 5, 6, 7, 8 times over the last couple of years. So obviously, I expected it to be there through the natural occurrence, so therefore you actually dismissed me. Because a fixed term contract is not there to get away from the law or to get away from actually employing an employee on a permanent basis and get away from benefits. It is purely there for a defined period of time and must be justified. And that's if you earn above the threshold. If you earn below the threshold, the laws, the amendments in 2015 to the Labour Relations Act is very, very strict on the new way forward. Now, if you look at Section 198, they brought in a deemed provision. And what this means is to say that if you earn below the threshold, an employer may not have a fixed term contract for a period of longer than 3 months. If it is for 3 months and 1 day and longer, the employee will be deemed permanent automatically. You may also not renew a fixed term contract. So if you had a fixed term contract for a month and you renew it, the same provision would kick in. It's also deemed permanent automatically. So you can only have one contract and may not be for a period of more than 3 months, otherwise the employee is deemed permanent. And what does this actually mean? Does it mean that the employee is permanent and they must be taken onto your payroll, all those sort of things? There's quite a lot of controversy in constitutional court cases. And if you want to read up, the very newest one is the assigned services case in the Constitutional Court that gave us some guidance. Let me rather say confuse all the lawyers out there to an extent. But the deemed provision then kicks in and says you are deemed a permanent employee, and the same laws would apply to you if you want to terminate the contract. Otherwise, it would be deemed unfair dismissal. So without rambling on about this, this basically means that please be very careful of how you use contracts for employees below the threshold that you have. Now, with that being said as well, there are certain ways and means that we would need to look at it, and there's justifiable reasons when employee below the threshold may actually work for longer than 3 months, and there's 8 justifiable reasons that we will go into that I will explain that makes it legal for us to do. And I'll get that on the next slide or so. So first of all, we need to understand that parties to the employment contract, and that is your employer versus employee. And as I said rightly, you contract from an employer's side to the employee's side in return for some kind of gain, normally remuneration or payment in kind or whatever it should be that you choose or agree upon, commissions, and then the employee works for you. Now, when you start this relationship, as I said, that the employer has certain duties that they would have towards an employee, and an employee has certain duties that they would have towards an employer. I'm going to unpack these a little bit to show you what your rights are from an employer's perspective and an employee's perspective. So the first one is to receive the employee into service. What does this mean? This means that you would actually need the employee to come to work. You can't halfway through the month say, hi guys, well done, you've made your sales target, and therefore please stay at home, and I'm not going to pay you, I see you next month, and we do the same again, and you save on cost. There's a contractual obligation if you sign that the employee must work the full month and you must remunerate them for that. So you must actually receive them into service. Next duty is to also remunerate the employee, whatever is agreed upon. If you've agreed upon bonuses, profit sharing schemes, extra days leave, time off, and lieu of overtime work, all those type of things you need to either remunerate or give time off, whatever the agreement is, and you need to abide by whatever contractual obligations you have signed. Then there's also a safe working environment. The employee needs to provide a safe working environment. What does this mean? Does it mean leather couches and special machines, nice desks, all those type of things, comfy leather chairs. No, definitely not. What it purely simply states is that you must provide a safe work environment where an employee can work without the fear of being harmed. So no live wires through electrical plugs. The ceiling should be safe, doesn't fall. The building should be stable. There should be demarcated smoking areas so people can't smoke in offices, those type of things. Or if you make it a little bit more specific, there should be a policy or a first aid kit available. Should there be a dog or that bites or a cat that scratches, it's part of the hazards. But there should be a policy in place to say if this happens, the following would happen. And there's somebody on standby, we take you to this hospital, we already have your medical aid details on record, those type of things. And the employee should just be aware of these things and have a policy in place to say, accidents do happen, and if it happens, then I did my best to create a safe working environment. But if it happens, there is a policy in place for what the next step should be, and that should be sufficient in law for this. You can't necessarily have a kennel where all the dogs are open and say, "Hi, go and feed these guys," without any protection on. And while there might be some aggressive dogs, that would not be seen as a safe environment. Need to be kennelled up, all those type of things as per law. Okay, the next step would be to comply with all contractual duties. So again, it comes back to if there's bonuses, 13 check, whatever you've agreed upon in the contractual duties, you need to abide by that. And then you need to comply with all statutory duties. Now, statutory duties is everything that's described in the Basic Conditions of Employment Act and the Occupational Health and Safety Act. And these are the bare minimum. So this is your 4 months unpaid maternity leave, minimum of 15 days working leave, 30 days sick leave in a 3-year cycle if you work a 5-day work week. If you work a 6-day work week, 36 days sick leave in a 3-year cycle. And this is the minimum that the employer must grant the employee. So nothing precludes the employer from actually saying, I would give you 20 or 25 days leave or 50 days sick leave in a 3-year cycle, or maternity leave will be paid pro rata, all those type of things. The basic conditions is the basic minimum that the employer must pay to the employee, but nothing precludes an employee from negotiating more beneficial terms than the basic conditions. Okay, so what's the duties of the employee? As we work in law, if there's something good for the employer, there must be something good for the employer as well, and certain duties to strive towards. And their first one would be, as the employee should receive you into service, the employee should actually come and remain in service. So that doesn't mean that the employee can come to work, clock and say, "Hi boss, I'll see you at 10 o'clock, or I'll see you at 1 o'clock, I'll see you at 2 o'clock, but I'm here, I'll work from home," those type of things. It means that if there's no agreement, you work from the workplace and you must enter and remain there, and you must perform to the scope that you've agreed upon in your contract. The next one talks quite a lot to this, and it says that you must maintain reasonable efficiency. And I'll unpack it a little bit later for us as well, what is reasonable. To give a heads up on this, it means that it's not unlawful and it is possible. It does not enjoy the impossible, and it's not illegal. That's the legal definition of reasonable. So as long as you can prove those two terms, then it would be a reasonable term, and you can choose as the employer what the performance parameter should be in your workplace. Also, to further the employer's business interest, this would be if some of your employees actually get clients and say, "Hi, the vet down the street, they've got a special on neutering this month, maybe you should go to them," instead of coming to your shop and saying, "But hi, this is it, all the dog food's a little bit cheaper if you go around the corner at that private home." They should have the employer's best interest in hand and try and make the sale for you, and not give business away. There's a legal duty on employees to do this. The next duty on employees is to be respectful and obedient. Now, respectfulness goes both ways, from the employer to the employee, but unfortunately, an employee cannot give its employer instructions to obey. They've accepted a position where they take instruction and they report into a higher position, and for that reason specifically, they need to take instruction. from their manager. Then the last duty is to refrain from misconduct in general. This means don't steal from the company, don't sell the milk of the company, don't harm animals, the normal basic needs and misconduct in general. That's also in trite law, or we call it common law principles. It may not be even reduced to writing, to be respectful and obedient, to be nice to customers, to not shout at them. These type of things, it's seen as misconduct if you do it, so they would have an obligation to fulfill these duties as an employee as well. Now, if these are the employees, you guys will see this is the list from the Basic Conditions of Employment Act, and this is the contents of an employment contract that must be on the contract itself. So the employee's full name and surnames, commence date, end date, if it's a fixed term contract, is it temporary, is it permanent, job title, brief description of the job, place of work, and it goes on to the notice of the employment relationship. As such, these are prescribed by law that must be contained in a contract for it to be valid. Especially if you are below the threshold, if there's no contract in place and you're on a fixed term contract, you are automatically permanent. So there must be a contract in place if you're below that. Otherwise, there's a little bit of problems for you as the employer. Now, here's a little bit of a description that I put up for you guys to say what type of description it is with the contract category and the type of employment. And it just is just a breakdown of what it is. Now, we've talked about the different types of employees, permanent employees, temporary employees, and then there's two more categories, and that's casual employees. Casual employee is somebody who doesn't work for the employer for more than 24 hours per month. And that person is not actually deemed as an employee in the eyes of the law. They are seen as a casual, and you do not have to have a contract for them as long as it's not more than 3 days per month that they need to work. And then we have part-time employees, and these persons work for the employer on a certain time of the day, or in the mornings or the evenings, the drivers, those type of things. And they work on certain days of the week, mostly limited to 3 days per week. And this person can either be temporary or permanent. You can choose depending on the contract that you would write for them. Okay, so let's get to the gist of it. I've talked quite a lot about the Section 198 on the fixed terms, so let's get into it and see what the law says. So as you can see here, Section 198B stipulates a fixed term contract. It means a contract of employment which terminates, and it's only one of three things: on the occurrence of a specific event, the completion of a specific task or project, or on a fixed date other than the employee's normal or agreed upon retirement age. It goes on to say, employers may only use a fixed term contract or successive fixed term contracts for longer than 3 months of employment if the nature of the work is limited or a definite duration, and the employer can demonstrate a justifiable reason that I've talked about. And let's go through these 8 justifiable reasons that the law accepts for if a contract can be for a period of longer than 3 months. So the first one, if the employer replaces a permanent employee that is temporarily absent. So this is normally with maternity leave or where somebody's ill in hospital for quite a period of time. And if, let's say, for instance, you granted 6 months maternity leave, then this employee can stand in for another person for 6 months as long as the job stays open for the other employee to return. This would then be a justifiable reason, and that means that the employee is on a fixed term contract for 6 months, even if they're below the threshold. That's fine to terminate the contract after 6 months. But you must be able to prove that there was another employee that was temporarily absent. If there's also the next ground is if there's a temporary increase in volume of work of an employer, provided the contract is not for a period of more than 12 months. So this is, for instance, if there's, it's for instance in the manufacturing industry, if there's a new line of cars that's brought to South Africa, and these employees would need to work on a specific vehicle, you can get people for a defined period, not more than a year, to work on this increase in volume. But it must state that it's for this increase in volume. And if it gets challenged, the employer must prove that there was the increase in volume of work, and quite a substantial one that justifies the number of people that you've actually appointed. The third ground would be If an employee is a student or recent graduate being trained for a profession, we call them learners, then it can be for a period of longer. Normally, these learnerships do not extend for longer than 12 months because they need to be registered with the relevant CETA as well. Then fourth ground, if the employee is actually engaged in, to work on a genuine or specific project. Now, this is predominantly it. And the onus on the employer needs to provide that it's a specific project or genuine project, and you wouldn't be able to provide proof that this is a specific project. And if the employee is not a citizen and the work is linked to a work permit, seasonal work, an official public work scheme, or if an external resource funds a position. So this is also linked to a learnership in some way. You would say to a non-profit, I provide a person's position for the next year to do a specific task, and I fund it, and thereafter the position becomes null and void. That will also be seen as a justifiable reason. And then also the last one is if the employee has reached on a normal or agreed retirement age. After that, the law doesn't protect you because it seems that you have already had your chance to work, and therefore you don't really benefit from the LRA in any way or form as such. So if we briefly just end this off with the fixed term, section 198B5, an employment in terms of fixed term contract which contravenes the section is that it's deemed to be an indefinite duration, and therefore you would be deemed to be permanent as such. Okay. So what's the employee's rights with contracting? Employees are entitled to ask for written terms and conditions. If there was never a signed contract, an employee is still entitled to request such a contract. If the employee has been in employment without a contract, he or she cannot be forced to sign a new one as such, and then you would work on the practice rule, meaning the contract is what the normal work has been done, the job description, how the employment has been. And this is normally quite difficult to prove because you would need to call witnesses if it's challenged in the court of what I've normally done, what was my task, how much I've been paid, all those type of things. The employment will also continue under the custom and practice rule created between the employer and the employer, as I've explained. And the relationship can be formalized through a contract, but it can be changed without consent from the employee because they are deemed terms and conditions of employment. Now, what is the employment contract sets out? You can set up a probationary period where you can test an employee. This is normally 3 months. A sick pay scheme, additional leave, pension schemes, and any further benefits to the employer. And also what it must confirm what the rules and regulations are that the company upholds. This means your disciplinary code, your policies and procedures, all these type of things. That must be there. Now, to briefly touch on that, how would it be enforceable to say, and the types of rules. Employers are not obliged to negotiate the rules of the workplace with unions or employees, and these rules must be imposed, can be imposed unilaterally. The prerogative to establish rules within the workplace lies with the company, and the employees or unions cannot interfere unless they are wholly unreasonable and lawful. And then you would see here, I've put a little bit of a slide together for you to say, what does it mean? What is common law rules? What's express agreement rules? And what is implied rules? And these are the normal type of rules that you would have in the workplace and they would have. You guys can read through that to see what the difference is. It's just the legal definitions of it. And then let's look at the enforceability of the rules. There are 3 key principles which will allow an employee to determine whether a rule is enforceable. I've talked about this, and this is straight from the LRA and the Code of Good Practice. Was the rule valid and reasonable? Was the employee aware of the rule? And was the rule applied consistently? And if you follow these 3 principles, a rule would be enforceable. And then here is the breakdown, as I previously said, of what is valid and reasonable. In order for a rule to be enforceable, it's essential that it be valid and reasonable. And reasonable means it does not require the employee to do the impossible, what is illegal. It doesn't discriminate against any person unnecessarily or between different classes of workers. And the rule is not sprung out of the blue. And then a valid rule means you have the authority to do it. It complies with the applicable statutes and regulations, and the rule is required for the efficient, orderly, and safe conduct of the employee's business also known as the economic. There must be an economic rationale for this. So if you follow these principles and rules and apply it in such a way, then you'll have a very good chance of winning all these cases at the CCMA going forward. So also then lastly, the law says that the employees must be aware of all these rules, and here's just some ways for you to make employees aware of rules, and it's through awareness sessions, your contract, policies, procedures, emails, notice boards. It can be a common industry rule as such, and you guys can read through this as well to say this is how you can make employees aware of rules. Also, these rules must be consistently applied, so what's good for the one employee must be good for the rest. However, we can differentiate. So normally if a tea lady is 10 minutes late, that might not be seen as quite so serious. But if the person that opens up the shop in the morning is 10 minutes late and there's a queue of customers that's backed up and you can't do sales and some people has left, that's quite a lot more serious type of misconduct, because the position requires a lot more care. So it doesn't mean for the same offense you need to give the same type of warning or take the same steps. It can be different, as long as you can differentiate between these two types of employees and the seriousness of the transgression. Okay. Now, what we've also decided, if there's any questions for you guys or you would like an audit, we've decided that if there's a need for you guys to not sure if you are compliant with all the legal aspects of industrial relations, your contracting side, we will do a free audit for you guys, and you can just book it through us. All our details will be up on the website, and we will do a free audit for you guys to ensure that you are compliant, and depending on the audit outcome, we can always have a look at how we can implement these types of things. So first of all, thank you very much for your time, and I appreciate it. And if there's any further questions, please find us on our website, where you can interact with us live through some of the chats. Thank you very much.
Aldo, thank you so much. This was incredibly valuable. Just to mention to the listeners that are tuned in, Labournet has offered the free audit to all of the candidates who are attending the summit, and we thank you for that offer. And I know I did that in my business, and it was incredibly valuable. You gave me a full detailed audit, and we were able to fix a lot of things that helped us and saved us a lot of money going forward. So thank you for your session, and I'll post your details just below the video on the website. Your logo's there as well. Anybody can just click on the logo and it takes them straight into your website, and they'll get your contact details there. Otherwise, they could just leave a comment below the video and we'll get back to you on that. So thank you.
Thank you very much, Carl.